good evening, all. Call this hearing to order. The purpose is to determine whether 3 board members of the Housing Authority of Clayton County neglected their duties and/or participated in misconduct in office, warranting removal from office by voting to suspend the executive director, Mr. Michael Bryant, Mr. James Fambro, and Ms. Karen Lanier. And before we go any further, I'm going to ask that we stand, do a moment of prayer, and then do the Pledge of Allegiance, as we have always done so. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, before we start, Ms. Karen Lanier, who is absent today, contacted my office and wanted to get a continuance on this matter because she was already scheduled to be out of town. She does take this matter to be serious and would like to be here to represent herself. Therefore, I will ask the board whether or not they will grant her a continuance, and I will put that in the form of a motion if there's a second.
I'll second it.
Probably moved in second. Any questions?
I have a question. Mr. Hancock, Ms. Lanier sent an email and you responded to her. Does this differentiate any from the response you gave her in the email about being present, moving forward, or?
I think we copied.
Speak in the mic, please.
Excuse me, I'm sorry. I think we copied each of you on the email response that we'd sent her, which was that because you don't meet again until the 16th, that the board could not act on her request. And I think I advised her that she should either be present or have someone here on her behalf, a representative here, was what the email said. But that you could, because you could not deal with the issue of the continuance until you met today.
Thank you.
And as I stated earlier, she was out of town the week prior to and this week as well, starting on yesterday. So, again, there's been a motion and a second. Any other questions? Hearing none, those in favor, aye. Aye. Oppose?
Nay.
Nay.
All right, motion for continuance fails. Before we hear from Mr. Hancock in reference to some of the notifications, I just want to make it clear that we have established the purpose for this meeting. I am the chairman, therefore I am the presiding officer for the hearing, and as such, I'd like to remind the board members that they must be recognized by me before asking a question or making a motion. The order,
I have a question.
let me finish,
Okay.
and then we'll go back. The order that this hearing will proceed is as follows. I will ask Mr. Starr or his legal counsel to state the allegations against the board members. I will allow the housing board members to state their case or position individually or collectively, whatever they prefer. And then I will entertain questions by the board directed towards either party. And then I will allow a closing statement to be made from either of the parties. And then we'll entertain a motion. Now, Ms. Hambrick.
Where is it stated that the chairman presides over this hearing?
As the chairman, I am the presiding officer over all matters.
Where is that stated, sir?
Mr. Hancock.
I think the county code provides that the chair will preside over the meetings. I mean, it is that, I can't cite you the code section, but it does provide that he will preside over the meetings, if that's the specific question.
Over hearings? Consider me.
No, ma'am, it does. Hearings are not addressed. There is no provision in the county code with regard to hearings. The state law 8353 indicates that the hearing will be in front of the Board of Commissioners. So,
I would like for this hearing to be presided over by an attorney. And I would like for
Here's
that to be
mine.
you. And I would like for that to be you,
The county
Mr. Hancock, the county attorney. Can I,
I think there's a conflict with Mr. Hancock presiding over the hearing. So if we need counsel other than me, then we can adjourn it.
And what would be your opposition to me presiding over this hearing?
well, I just want it to be fair and legal or whatever,
We
but
all
I'm
want it-
fine.
We all
If-
want it to be fair.
If
I
you,
agree.
I mean, if everybody's fine with you presiding, I'm fine. I just want to make sure that that was stated and that is legal.
Is it, Mr. Hancock, will I be in line to offer a motion that the county attorney facilitate the hearing?
I believe that's a conflict of interest.
Not only that, she's
Well-
not prepared for conducting this hearing.
I don't know that there's
No,
a
he's-
conflict of
she's a-
interest because I don't have a role other than advising you on legal questions. I mean, what we're talking about is, I think, from a standpoint of presiding, is the role of the presiding officer should, I don't think, be anything more than just recognizing those people who want to speak and maintaining order.
Right.
I think any ruling regarding any acceptance of evidence or what the issues are, or those kind of things, is a board decision. Y'all are going to have to make that decision if it becomes an issue. But simply presiding over the meeting is nothing more than just keeping order. Although I will defer to Ms. Rooks with regard to the conflict. I do think you may have to ask me questions, and if you did that, then my role as in the presiding capacity might, there would be an appearance potentially of a conflict there anyway.
Okay.
So,
We'll move forward.
Any other questions? Okay. Mr. Hancock, you were gonna make some notifications.
all I'd like to do, Mr. Chairman, is that at the instruction of the board in Resolution 2016-155, we were directed to provide notice to Mr. Bryant and Ms. Lanier and Mr. Fambro of this hearing in accordance with the law. And we did that by certified mail, regular mail, and email, and attached a copy of the resolution to those notices. And I would simply like to make those a part of the record for the purpose of the hearing.
Duly noted,
I'll
please
give
give
it
it to
to
the
the
clerk. This time I'm gonna ask for Mr. Fambro and Bryant to come forward.
Before we do, as a matter of procedure, should we not state what this board's resolution, can we reiterate that resolution
You have the resolution.
verbatim?
Yes, sir, I do. Yes, sir.
Could you read that verbatim into the record? And also, I'm gonna ask if Mr. Starr is present or his legal counsel. Anybody representing him? Mr. Starr, legal counsel. So not even show up, okay. Proceed on.
Resolution 2016-155 is a resolution authorizing the Clayton County Board of Commissioners to conduct a hearing consistent with OCGA Section 8353 to determine whether any members of the Housing Authority of Clayton County shall be removed from office, to authorize the Chief Staff Attorney to send notice of the hearing, including the charges, location, date, and time of the hearing as required by statute, and to provide an effective date of this resolution. Whereas with regard to Housing Authority Commissioners, OCGA Section 8353 states that for inefficiency or neglect of duty or misconduct in office, a commissioner of an authority may be removed by the mayor or, in the case of an authority for a county, by the governing body of said county, provided that a commissioner shall be removed only after he shall have been given a copy of the charges at least 10 days prior to the hearing thereon, and shall have had an opportunity to be heard in person or by counsel. In the event of the removal of any commissioner, a record of the proceedings together with the charges and findings thereon shall be filed in the office of the clerk. And whereas on April 28, 2014, the Housing Authority of Clayton County Board entered into an employment contract with an executive director And on July the 7th, 2016, the Housing Authority of Clayton County Board voted 3-2 to suspend the executive director indefinitely without pay, which may be in violation of paragraph 7 and paragraph 8 of the employment contract. And whereas at their regularly scheduled meeting on Tuesday, July 26, 2016, the Board of the Housing Authority of Clayton County found James Fambrough guilty of misconduct in office for changing the locks at the Housing Authority office at 732 Main Street, Forest Park, Georgia, and disconnecting the executive director's computer without authorization from the board and against the advice of legal counsel. And whereas the Clayton County Board of Commissioners wishes to determine whether members of the Housing Authority of Clayton County Board neglected their duties and/or participated in misconduct in office, warranting removal from office by voting to suspend the executive director. And whereas the Clayton County Board of Commissioners deems it in the best interest of the county and the county will be best served by conducting a hearing on this matter consistent with OCGA Section 8-3-53. Now therefore be it resolved by the Board of Commissioners of Clayton County, and it is hereby resolved, Section 1, the Clayton County Board of Commissioners hereby authorizes the conduct of a hearing consistent with OCGA Section 8-3-53 to determine whether any members of the Housing Authority of Clayton County shall be removed from office for voting to suspend the executive director or for changing the locks at 732 Main Street, Forest Park, Georgia, and disconnecting the computer of the executive director without board authorization and against the advice of the authority's legal counsel. Said hearing shall be held on Tuesday, August 16, 2016, at 112 Smith Street, Jonesboro, Georgia, at 6 p.m. The members of the Housing Authority of Clayton County to be reviewed are Mr. Michael Bryant, Mr. James Fambrough, and Ms. Karen Lanier. Section 2, the Clayton County Board of Commissioners hereby directs the Clayton County Chief Staff Attorney to send written notice of the hearing, including the charges, location, date, and time of the hearing to each member of the Housing Authority of Clayton County to be reviewed not less than 10 days prior to the scheduled hearing. Such notice shall state that each member of the Housing Authority of Clayton County to be reviewed has a right to be heard in person or by counsel. Section 3, the Clayton County Board of Commissioners hereby directs the clerk to the commission to record the hearing and keep a record of the hearing on file in the office of the clerk. Section 4, this resolution shall be immediately effective upon approval by the Board of Commissioners. So resolved the second day of August 2016, and it bears the signature of each of the commissioners.
So they obviously was properly served in that respect. Let me ask the question. Mr. Starr, was he given notice to be here as well?
We did not give him any notice, no, sir.
Why not?
I don't view this as a hearing in which, and I think the code does not either, in which Mr. Starr is the prosecutor or the person making the charges. This board, by majority vote, made the allegation or accepted the allegations as providing a basis.
He was the requester of this hearing. So why would you not be here to give the board members an opportunity, a due process, to cross-examine or ask any questions that they may have of them? Why was that right taken away from them, or why didn't we have enough foresight to ask that question or have him to come to this hearing?
I believe Mr. Starr is aware of the hearing as evidenced by his communications to you.
Absolutely.
The law doesn't give you any right to have subpoena power, so you don't have the authority to compel him to be here.
But we didn't even ask.
No, the code doesn't require that he be asked, and y'all didn't direct us to ask him, and so we didn't ask him. That's exactly right. It's my understanding that he has provided, and this is again based upon the email that he sent, that he has provided certified copies to the clerk of certain documents from the Housing Authority and an affidavit, which I would assume he provided that for that to become a part of the record. But that comes from the email that he sent to all of you, and I have confirmed that the clerk has those documents.
I have a question.
Sure. Yes, ma'am.
Procedurally,
Yes, ma'am.
hearing started at 6 o'clock.
Yes, ma'am.
And we are taking evidence.
Well, I
do we
think what
call it,
you're
we're
doing under the code is you are providing the charging parties with, or the charged parties with the opportunity to be heard on the charges. You know,
The resolution, that's considered the charge.
the resolution is considered the charge. That is correct. And it is my understanding, and I will tell you, because I intentionally did not want to become a part of the facts, because the facts don't matter, I don't think, here. I hadn't reviewed what was sent. But my understanding is that what was sent was certified copies of minutes, the contract, and an affidavit. And I think if they are properly certified records of that body, then you could take notice of those and consider those because they reflect the actions of that body.
But those certified copies, if they would have been sent prior to this hearing.
I understand they were delivered to the clerk at some point in time.
Right, before 6 o'clock today. So
believe that to
under
be the
any
case.
normal circumstances of any hearing, whatever's to be considered would be delivered during the course of the hearing. So whomever the charged party is can't have an opportunity to speak against that, or because there are allegations, obviously, right? How do they know what the allegations are if we're going to consider those?
The allegations are what is in the resolution. That's
Okay.
it.
Okay,
The-
so then, the certified document that Mr. Starr sent before this hearing, how can that be considered if they've not had an opportunity to review it?
There is no, I guess, I would assume that they've had an opportunity to review the minutes since they were part of the meetings.
That's
And
not all
those are the meetings of the minutes. I would assume that they are familiar with the contract because they're the body that they sit on is a party to that contract. The only other issue, the only other item that I recall as being tendered was an affidavit.
And a letter from Mr. Starr.
Now, yeah, if there was a letter from Mr. Starr, I don't know anything about that.
There's a letter from
but-
Mr. Starr,
but-
there's an affidavit from Joe Harris.
Okay,
There's an employment contract, there are draft meeting minutes. I understand there are final minutes, why there aren't final minutes, but I have a draft of the July 26, 2016 minutes. So procedurally, I mean, wouldn't they not have an opportunity to review what he's alleging?
again, I think we go back to the allegations being contained in the resolution.
Then we shouldn't consider this either.
Unless you're going to take the allegations as being true. If your question is, do I think that it is legally permissible for you to consider certified documents of an agency that you are reviewing whether to remove people from, my answer is yes.
But it's not from the agency, it's from the executive director.
Are they certified by the executive director?
Well, I don't know what I have a document that was emailed. You're contending that what he emailed to us is certified.
Can we see the originals of what was delivered?
Certified by the secretary.
Third page of what I'm looking at as attachment 1 has a certification by Deborah Lyles, I think is the secretary of the Housing Authority Board. That,
She's certifying the minutes.
the minutes, yes, ma'am.
Okay, my certification is attached to a draft. So she's permitted to certify draft minutes.
The Open Meetings Act requires that minutes be made available within, if I'm not badly mistaken, 48 hours of the date of the meeting. Most governmental entities do not meet again within that time frame. So I think it would have been improper for her to certify them as being approved minutes because they hadn't met to approve them. But I don't think it's improper for her to certify them as being draft minutes reflecting what has what the minutes reflect has happened. I'm assuming these minutes have not been approved by the board because I'm assuming they haven't met again.
Mr. Chair, you outlined the agenda. I mean, can we move forward in the way that you said in the beginning
So
that
as soon as,
the
yes,
hearing
as
will
soon
go?
as Commissioner Ricks finish her questions.
So on the minutes that you have is dated June 28th, correct? That's a draft?
That's the first one that I'm looking at that the clerk was, yes, ma'am.
And the second one is dated July 6th
Yes, ma'am.
as a draft.
Yes, ma'am.
So conceivably, they met on July 6th if there were minutes.
I agree.
So there would have been an opportunity to have final minutes from the June 28th meeting?
I don't disagree with you there. I don't know the answer to that question.
So how can we accept a draft when there was an opportunity to finalize it on July 6th?
If you, hang on just one second. I was just looking at the minutes to see if there was any notation of whether those minutes, those prior minutes had been considered. As you know from your future job, if they're properly certified business records, then they are admissible for whatever weight the trier of fact wants to give them. And she has certified that they are records that reflect the true and accurate summary of the proceedings captured herein to the best of her ability. If any of the respondents want to disagree with that, with them being true and accurate copies of the minutes, then that might raise a factual question, but I don't think it makes them admissible. But again, that's your call.
Right.
The letter, my personal opinion is that the letter is not evidence. And I would not recommend that the first letter, I would not recommend that you make that a part of the record because it's not certified, it's not sworn to. It's a communication, but I would not, if we're going to adhere to the rules of evidence, and you don't want to consider that as a communication to the board, then I think that's your choice. There is the confusing part about the statute is that it does not effectively provide for a prosecutor. It provides for allegations to be made, which were made in the resolution, and then it provides for an opportunity to, on the part of those against whom the allegations are made, to respond. And the allegations were made, and you and I discussed last week whether they constituted facts or not, and I told you, and I still contend, that they don't constitute facts, they constitute allegations. Somebody has submitted certified copies of records that I'm assuming they contend constitute proof of the facts alleged and upon which the hearing was called. So do I think it's proper for you to consider those facts? Yes, I think you can consider certified copies and affidavits. It's interesting because the statute makes no provision for the right of cross-examination, makes no provision for the right of to question those that are accusing. But I think the way it is set up, what it says is if there are allegations that are made, and this board, based upon whatever review you want to make of whatever documents that are available to you determine that those allegations are accurate, then the respondents have the opportunity to be heard on that, and that ultimately you determine whether the allegations are accurate or not, and you then determine what, if anything, you're going to do about it. Those are the two simple questions that I think are before you.
My concern is using the document that was submitted to us. I don't think, and we're gonna differ here, I just don't think under the business record rule, this certification rises to what would be sufficient to have this admitted as evidence.
Well, not only that, but this document that was presented to us is the only thing we have to go on. We're not afforded the luxury of asking any questions of Mr. Starr or even his legal counsel, or even to have them ask questions, because they chose not to show up. So, and I'm assuming that they're still not here, so
Isn't
let's
it clear
proceed
that
on.
we're here to hear from the members of the Housing Authority Board and not necessarily Mr. Starr?
I understand where you are, Mr. Chairman, and I agree with Commissioner Gregory. It is, in my opinion, the underlying decision of the Housing Authority Board is not the decision that is before you. Because if that were the case, you would be taking their position. And nowhere in the law does it give you the right to take their position. So I believe that in order for this, the only way that this procedure can work and for this statute to be interpreted is that you start with an assumption that there was a basis to terminate the contract, and that you not look beyond that, behind that point. And then from that assumption, you decide whether or not the actions as alleged in the resolution occurred, and if they did, whether or not they give rise to removal of these individuals. Otherwise, if you go behind the question of whether or not the termination was proper, then you are inquiring into the way they do their business, and you don't have that right. You have only got the right to decide whether or not they acted
Misconduct,
negligence of duty or misconduct in office. That's all.
To get to that point, we have to be able to get all the facts that's presented before us.
Mr.
And
Chair,
without that, hold on a second, and without that, we're not getting all of the facts. And that's my only statement there.
Mr. Chair, I offer a motion
won't
that we
argue with that.
proceed with the
I didn't
hearing as you
recognize the motion, but we
outlined.
are going to move forward. With that being said, obviously, I'm going to ask once again, is Mr. Starr or his legal counsel here? As outlined, that was the first part of the hearing. The second part will be for Mr. Fambro or Mr. Bryant. You can come collectively or one at a time. I think we probably, for the sake of the hearing, need to take you individually. So, Mr. Bryant, why don't you please?
Mr. Chairman, I'd like to offer a motion that we take Karen Lanier first.
She's not here. We've already. No, ma'am. No, ma'am. Are you legal counsel? No, I was asking for a legal counsel, or were you, are you?
I'm willing to stand and represent her.
Have you spoken to her and she wants you as representation? Because she did not, I'm not going to allow it simply because she did not convey that to me. So, no.
I just feel that it's fair that, I hate for someone to be prosecuted.
Ma'am, Ms. Gorey, thank you. Thank you.
I have a motion.
What was your motion again?
My motion was that we start with Ms. Karen Lanier, then Mr. Fambro, and then Mr. Bryant.
I second that.
Properly moved and second.
is that even proper during a hearing? Or does it have motions? Aren't we just hearing evidence?
Yeah, they're either here or they're not. And I've already stated that Ms. Lanier is not here.
I believe the board has the authority to establish the procedure. if they want to do that. And this is a procedural motion as to how you'd proceed.
The order.
Thank you.
All right, it's been motion and second. Those in favor, aye.
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 Opposed? It's unanimous. Ms. Lanier is not here. Calling Ms. Lanier, she's not here. Mr. Bryant, please.
Can we go ahead and take action on Ms. Lanier?
Would you want to take action before you have the hearing? Or hear the?
Well, she's not here for the hearing.
Yeah,
we
but
still
they did
do
it as a
something.
collective group.
But she's still afforded due process, so you're gonna state what you believe, no, let her say what she believes she did.
Do you want to proceed on?
No, the attorney said, sent an email telling her that she needed to be here or have a legal representative.
But she's still afforded due process. Just because she's not here, it doesn't negate your responsibility to find that she's breached something according to OCGA 8353.
I don't mind hearing all of them and
You have not
considering
heard
it.
1 ounce of explanation from anyone, but you're already ready to pass judgment.
Oh, no. I just wanted to hear.
Just hear
From Ms. Lanier
everybody, and then
first,
just
right.
do everybody.
That's fine with me,
Mr. Bryant,
individually.
please proceed.
Thank you, Mr. Chairman. And based on this debacle of a meeting, I'm going to ask that my board, which is myself, Mr. Fambro, Ms. Lanier, be afforded to have legal representation, because we are dealing on allegations and opinions and not on facts. So with that, I'm going to ask you guys to grant us that opportunity to have due process, especially in light of the fact that the accuser, an executive director who's a contract employee, a vendor, have the right to make a charge or an allegation, and 3 members of your particular board take those allegations as truth and evidence. That is extremely troubling to me as a citizen of this county, as a citizen of the United States who understands and abides by the Constitution of the United States. And more importantly, taxpayers of Clayton County's time and money right now is being wasted as we speak, because we have a contract employee who knowingly and arrogantly
Mr.
breached
Chair,
his
see, we're getting
contract.
back into other issues. We're not sticking with the issues while this board is hearing it, and
So in other words, Mr. Starr is
himself.
present based on Commissioner Gregory's appearance. Mr. Starr is present based on Ms. Hambrick's presence. Mr. Starr is present based on Mr. Edmondson's
Chair, I'm
presence.
asking
Hold
you
on,
to
Mr.
please
Bryant,
give
hold on a
the
second.
public
Right.
hearing.
Mr. Bryant, hold on a second. Your opening comment was that you are asking this board for a continuance, so you will have an ample opportunity to hire legal counsel. Is that correct?
That is my desire, and that is my request to the board, being fair and impartial. If you allow an executive director to
Well, let me cut you off right there. Let's
sir.
just go with that, and I can sympathize with what you're saying. So I will place that in the form of a motion to have a continuance to allow you to obtain legal counsel. Is there a second?
I'll second it.
Properly moved and second. Are there any questions? Hearing none. Those in favor, aye.
Aye.
Opposed?
Nay.
It's 3-2. It fails.
Okay.
So with that being said, I'm gonna caution you, Mr. Bryant, to stick to the issue at hand
Yes, sir.
and address those allegations that have been made against you.
Very well. First and foremost, the allegations that are against me are based on opinions and also based on the fact that a person is upset to the fact that he cannot be chairman of the county. Let's look at the history of everything. Mr. Starr had
And
a,
again,
You gotta defend
let's-
yourself.
Let's talk about what your actions were.
my actions
And whether or
were-
not, hold on a second, whether or not you feel like there was a misconduct on your part or malfeasance in your part.
correct. And I'm glad you said that. First of all, let's define what misconduct is and what inefficiency in office is. There have been no definition to those particular charges. So for me to address something that has not been defined, to me, it's just shooting in the air. It's handicapping my abilities to really argue a point when it's just a broad stroke. Misconduct, what is that? Inefficiency of duty, what is that? Is it because I decided to protect the integrity of the housing authority by not allowing a contract employee to have carte blanche and have a rubber stamp board. So if that's what misconduct is the opposite of that, then let's put some definition to that. Let's not make opinions based on someone else's accusation that I have conducted misconduct. So misconduct has not been defined. Inefficiency in office has not been defined. There's been no definition to these charges here for myself and my other fellow board members. So how could we objectively argue a point when there's no definition? So I will ask Mr. Hancock if
Well, you
we
need
have
to
any
address-
definition of
Sir,
these charges.
Address this board, not Mr. Hancock.
Okay.
So,
Well, that's true, because Mr. Starr is present. So I get you.
so do you have a question for this board?
For this board, what is the definition of misconduct? What is the definition of inefficiency? What is the definition of me being derelict of my duties, who's defending and making sure that the integrity of the housing authority is not ever being compromised or challenged?
Any other board members would like to answer that question?
I have a question of the commissioners from the Housing Authority, and
For both?
for both, yes.
Okay, but
Right.
address it to Mr. Bryant. Or are you gonna wait till we collect?
No,
the answer?
I'll ask him now.
Okay.
Did you follow the advice of your legal counsel?
Yes, I did. As a matter of fact, I'm glad you brought that up. Mr. Mack, which was our legal counsel, advised me that we have discretion, just as every board in Clayton County have discretion as to how it handles employment issues and contractual obligations. So yes, I did have advice from counsel. The advice from counsel remedied that I have discretion. His advice was if it were him, he would allow the 30-day breach period to conclude itself before suspending Mr. Starr. However, in his words, it's the discretion of the board. So to answer your question, as a matter of fact, I did have legal counsel. I did have an opinion from legal counsel. And I acted within the guidelines of the D word called discretion that the Housing Authority bylaws grant me. Next question.
I just wanted to point out, one of the things I was reading is the documents enclosed here from Mr. Joe Harris that state that the Housing Authority members acted against his advice with the actions that they took. And some of the actions that the Housing Authority board members took, he was not even aware or found out later that they had taken these actions and without any kind of,
Well, there again, you're talking about Mr. Joe Harris, and I'm talking about Mr. Robert Mack. So Mr. Robert Mack is also the legal counsel who attends 90% of our meetings. And when he's not able to attend a meeting, most often he sends his daughter to represent Mack and Harris law firm. So you're talking about an individual who, for the most part, is never present at our meetings, and who I have very little relationship with because he's never present. So once again, my comment and my response to Ms. Hambrick is, I did have legal counsel, I did have legal advice, and I acted accordingly to what my legal counsel instructed me by using my own discretion.
Just need to confirm something. Madam Clerk, did we receive an affidavit from Robert Mack?
Mr. Chairman, just the documents that were presented to me by Mr. Wade Starr.
aren't they partners? I mean, Mack and Harris, I mean, doesn't the firm, I mean, represent the Housing Authority? So one would be
No.
speaking for the
Let me
other?
ask you this, if your daughter had a meeting with someone and your husband was there as well, you decided not to show up, but your husband gave an opinion or something of that nature, but everyone really and truly wanted to hear from you because you're always there. Would that put you in a
That's not
mind?
the
Would
same
that bring
thing.
you?
I'm talking about the law firm of,
Well, I'm trying to shed
Mack
some
and
sense on
Harris,
your question here.
of Mack and Harris,
Uh,
and they represent the housing authority. Mr. Chairman, I'm gonna also ask too, for the sake of time, that we hear from Mr. Fambro.
Okay,
I
well,
have-
his due process, he
I
has
still
a
have
right to,
questions.
state his opinion and.
Let me also say this, Mr. Chair, and thank you so much. I realize and understand that the decision has already been made, and the decision has already been told by Mr. Starr to the 3 commissioners that sits on this board as to what his wishes and desires are. I understand that. I understand that the cards and the deck is stacked against me. I understand that. However, I'm okay with everything because the Housing Authority doesn't define who Michael Bryant is. Clayton County doesn't define who Michael Bryant is. There's no person on this earth who defines who I am. My definition of who I am comes from myself and my Lord and Savior. So I am fine with the daggers that are presented to me and stuck in my back. My God has given me big shoulders and I can bear them all.
Mr.
But what
Bryant,
I won't do is allow allegations against me to serve as evidence and fact, especially from the fact that Mr. Starr's arrogance once again has allowed him not to be present this evening.
Mr. Bryant, may I ask
Ms.
you?
Rooks has some questions.
Mr. Chairman, my pleasure. There was an allegation in our resolution that alleged that Mr. Frambo was found guilty of misconduct for changing the locks. Was there ever a hearing by the Housing Authority Commissioners finding that Mr. Frambo was found guilty of anything?
As a matter of fact, no, ma'am. The motion was put before the board by the chair, Tanya Clark, to censor Mr. Fambro. And the board voted 3-2 to not censor Mr. Fambro. So if you're not censored by anything, there's nothing that you could be found guilty of. Mr. Fambro volunteered to pay $260 back to the Housing Authority for changing the locks and the passcode to the Housing Authority's computer. Now, the Housing Authority's computer, or Mr. Starr's computer, belongs to the Housing Authority. It does not belong to a contract employee. So it's in the best interest when the contract employee has been suspended or asked to remove himself from the office, it's in our best interest to safeguard the institution. That's what any corporate entity does, and so that's what we took the liberty of doing through Mr. Fambro.
You received a copy of the resolution this board outlined with the facts, their perceived facts.
Yes, ma'am.
Before receiving that, had you been aware or advised that there was a belief that Mr. Fambro had been found guilty of something at the Housing Authority?
No, as a matter of fact, we never in our meeting discussed guilt or innocence. What we discussed was, should Mr. Fambro return the $260 back to the Housing Authority? Mr. Fambro agreed to do that.
Okay. One other question. There was also a vote, was there a vote about Mr. Starr being in breach of contract? Was there a vote?
Yes.
And what was the vote tally?
It was 4-1 that Mr. Starr was in breach of his contract.
Okay, but only 3 people were summoned here. for
And that's
this.
my confusion as well today, because if a board make a decision, that decision is representative of the board, not individuals of that particular board.
Okay, that's all I have.
Any other questions for Mr. Bryant? Thank you, sir. Ms. Fambro. And Mr. Fambro, again, let's keep our discussion germane to this issue.
Well, I just have one question. I just want to know why we are here. If anybody knows why we're here, I'll answer it. But we're here because the executive director of the Housing Authority of Clayton County breached his contract. He has a contract that states that we should be his sole employer. And if he is found in breach, he has a 30-day period to cure. He didn't even attempt to cure because he knew he had 3 votes, and he didn't even attempt to be here because he's already here. He's been here for 12 years or more. So, and I'd just like to say the arrogance of this person shows that he didn't try to cure. His 3 votes are here.
Are we answering the charge?
Hold on, I'm with you. How does that breach, and you said that's the reason why you're here. Explain to us your actions that you undertook because of what you're saying. What I'm hearing you say was the breach brought you here because you took action.
Exactly.
And the allegation is that you acted improperly.
Right.
So explain to us that.
Well, his contract, I've got a copy of it here. I know you guys have a copy of it, but you studied it for 20 days or whatever. But his contract states that if he's in breach, we have any remedy that we decide to attempt to clear the breach or give him an opportunity to clear the breach. The remedy we chose at that particular time was suspension. We suspended him over the objections of 2 members of the board, which is always that way. But that's why we're here, because he breached his contract, not because we did anything.
At some point, you rescinded that action, is that right?
Yes.
What was the time period between the time that you put him on suspension and the time that you rescinded that suspension? How many days?
It was probably 7 days, I think. I'm not really sure, approximately 7.
Okay.
And he had full use of his computer once again, correct?
He did. I'd like to explain that. In any corporate entity, when you have management decisions or management suspension or termination, then the first thing you do is take the keys, change the locks to ensure the safety of the employees. You change the computer code to ensure the integrity of your files. So what it is here, what they had was that, okay, we'll just suspend him. And then everybody just left. They adjourned the meeting quickly, but no loose ends were tied up. It was just, everybody was angry. And when they finally got together, Wade and all his cronies got together, then they came back with this, and Robert Mack is the person that's there 99% of the time. They had whatever the other man's name is on the phone. I don't even know how he got to be a lawyer. I really don't. But anyway.
Are we dealing in?
He's stating his position.
Okay. Were you asked to change the locks? Are you an officer? Two questions.
I just explained that. At any corporate entity.
No.
Is that a corporate
answer,
entity?
Answer a question.
Were you asked to change the locks?
Did I ask to change?
No,
Yes.
did the board ask you to
No.
change the locks?
That's what I just explained. They didn't even think about all the other things that go along with that. I have worked in the corporate community for all my life. So
But did you
obviously
contact
they
the
did not.
housing
I
authority
can only
or
answer one
president?
question at a time.
Hold on. Mr. Fambro, please.
So you took it upon yourself to change the locks?
I was there that particular day picking up a check, and that's what you do. That's it. It's the corporate entity because you're not on a foundation or anything, so you pay taxes under a corporation. So it's a corporate entity.
I have a,
Hold on a second. She had a second question, I believe.
Oh, she
Did
does.
you have a second question?
No.
Okay.
Miss-
Commissioner
Miss
Gregory.
Wright.
No, I'm finished.
Ms. Rhodes.
Mr. Fambro, at the time that you all suspended Mr. Starr, what was the intent of the board of his interaction with the housing authority after that suspension?
What was the intent?
Right. Did you intend for him to come back the next day?
Not, well,
Did you intend-
his contract says he has 72 hours to get his belongings. So on that particular day when I was there, he got everything out of his office that he wanted.
Okay, so the changing of the locks occurred after he removed his things?
Exactly. He left, he got in his car and left, and I had the lock and key people come in and do that.
So at the time that the locks were changed, there was no expectation that he will be returning to the premises?
Right.
Any other questions for Ms.?
I have just one.
Mr. Edmondson?
Mr. Fambro, just to clarify again, you as a commissioner on the board of the Housing Authority have what type of administrative duties as vested by the board?
I'm a board member.
You don't have any operational duties?
No.
And you receive no direction from the governing body, that board, to change locks or access the premise and tamper with the computers?
I didn't tamper with the computers. You have to use the right words. I'm not going to answer that.
Okay.
Tamper. I did not tamper.
Change the computers.
I changed the password. I had the guy
Okay.
come in and change the password.
Thank you.
Okay, but at any rate, though, we already knew what was going to happen when we got here today. Mr. Emerson called me up last week and said, told me what was going to happen. You guys were going to remove us when we got here today. And
That
I
one of
said,
the
well,
charges?
what's your position?
We
He
were sticking
said,
with the
well,
charges.
he said, well, I'm going to have to vote with them because the chairman's difficult to work with. So,
Is this a part of?
and
Questions for Mr.
oh,
Fambro?
I got one more thing I have here.
Is it
And
in response
also-
to the allegations?
Yes.
Okay.
Also, Mr. Edmondson sent me a complaint from a female citizen that had been living in Premier Garden. That's the Housing Authority.
That's not germane to what we're talking about, and that's your removal based on the allegations that have been presented before us. So I won't allow any more of that. Do you have any other questions for this board in response to the allegations?
You got any questions for me? That's all
Anybody
I
have
can
any
say.
any other questions for Mr. Fambro? If you like, I'll give you the last couple of minutes, because obviously there's nobody else here to speak.
Well, I'll say this.
For a
then.
closing statement that's in response to the allegations.
Okay. I've got
So
you.
I'll give you 2 minutes.
All right. Well, the only thing I can tell you at this point is I did the right thing based on corporate environment. Other people just as they do always. They vote, or they vote the way he tells them to vote, and then they move on. They don't understand that you've got to do the other work as well. I was the only one there at the time. The employees said, well, hey, when we normally do this, somebody gets fired, they change the locks, and they change the computer password. I knew that already. So I did that as a board member because no one else was really cared. But it's always that way. A coward throws a rock and hides his hand. That's what has happened because he's already present with 3 votes and an attorney.
All right, thank you, sir. Mr. Bryant, you have a couple of minutes to make closing remarks.
Thank you, Mr. Chair. It saddens me that we have to waste the county's time and valuable resources with some erroneous charges only because a person failed to take responsibility of his actions. As adults, we often tell children that there's a difference between right and wrong, and there's consequences behind our choices. And for us to have 3 adults sitting on this commission board to not ensure that an individual take full responsibility of his wrongdoing, and instead they condone that. That saddens me that so-called intelligent people put themselves in that position to not chastise an individual who's done wrong. Mr. Starr's done lots of wrong as it relates to the housing authority, as it relates to Clayton County.
Mr. Chair?
But no one is
Are we
here
sticking
to,
with the?
no one
Mr. Chair?
in
Well,
this
wrap up-
county,
Mr.
Wrap up
Chair?
your statements.
No
and make
one
sure
in
you
this
keep it
county-
in reference to your
Mr.
removal.
Chair.
yes, yes, sir. No one in this county ensure that this individual take responsibility of his actions. So we are here because we were protecting the integrity of the housing authority. We are here because we suspended an individual who breached the contract. And we are here now because that individual still has yet to cure the breach of his contract. His intention to cure the breach of his contract is to have 3 board members removed and 3 of his select board members installed to replace us.
Keep it,
And
keep it,
so
keep it,
that's
keep it
why
in
we're
lines.
here, based on
Got 4 minutes.
if my misconduct in office was a vote to suspend an individual for breaching a contract, then let's define what that misconduct is. Let's define what that inefficiency is. You all have yet to create a definition of that and propose a definition. Legal counsel has not either. And so we are wasting the taxpayers' time. I'm asking you all to do the right thing. Vote based on what is right, not based on what someone else wants you to do to be convenient for your own political career. Thank you.
Thank you. All right, any other comments or statements by the board members? All right, hearing none, is there a motion?
Mr. Chair, I offer a motion that the 3 Housing Authority members in question be suspended or be removed from the Housing Authority Board effective immediately.
We need findings of fact.
The code requires that there be findings.
Okay?
Okay.
Mr. Fambro, again, as,
Mr. Chairman, if I might, I would recommend you do.
Take the
I would
mic.
recommend that you do them individually.
Okay.
I just think voting on them collectively is not the way to go about it.
Okay, is there a motion, and let's take it individually
okay, Mr.
with cause?
Yes, Mr. Chair, I offer a motion that Ms. Karen Lanier be removed from the Housing Authority due to her not following the guidance and of the Housing Authority attorney and the actions that were taken to fire the executive director when advised not to.
Second.
Probably moved in second. Are there any questions or statements?
I do. I mean, is that procedurally correct, Mr. Hancock?
Well-
What's the,
Well, to suspend them I'm sorry, let me amend that to say when she wrongly suspended the executive director indefinitely, they did not adhere to the contract because I think there was a payout in the contract and they refused that as well, but an indefinite suspension actually was really a firing, but they did not hold to what they were supposed to do.
I mean, if we're gonna do this, shouldn't we do what the statute tells us to do? We gotta say what do you find as a factually occurred? And then we move forward. I don't understand how we're making motions.
Mr. Chairman, can I ask?
Mr. Evans?
Mr. Hancock, a statement of evidence within the scope of what we have, was there or was there not misconduct? Does it end with that, or does it need the documentation for what defines that misconduct?
The code requires that in the event that a commissioner is removed from office, there must be a record of the proceedings together with the charges and findings thereon. So I think that Commissioner Gregory's amended motion would be consistent with the findings or the allegations in the resolution and would be sufficient. The allegations were not termination, but I think they would be consistent with that, and I think that would be a sufficient finding to pass muster of the statute anyway.
Okay,
Thank you.
I got a motion on the floor.
Okay, second.
Hold on. You got an amended motion. And are you seconding the amended
Yes.
motion?
Do you remember what it was?
Yes.
All right. Any other questions? Hearing none. Those in favor, aye.
Aye.
Opposed?
Nay.
Nay. It's 3-2, it passes. Is there another motion?
Mr. Chair, I offer a motion that Mr. James Fambro be removed from the Housing Authority Board, based on the same, findings as, Ms. Karen Lanier, as was stated earlier.
How about for the record that we just,
Okay.
That's not
For
correct.
misconduct, we're gonna, based on misconduct, because again, with, misconduct as to not following the advice of the attorneys and the, improper suspension of the Housing Authority Executive Director.
Second?
probably moved and second. Is there any questions? And my question is, we're removing somebody for misconduct, but yet and still, nobody has explained what the misconduct or definition of misconduct, as Mr. Bryant has outlined.
Call to question,
Hold
Mr.
on,
Chair.
I'm not finished asking
Call
my
to
question.
What-
Call the
Procedurally,
Yes, you have to be recognized before you can call the question, and I didn't recognize you. So therefore,
Does he have to recognize me if I do call the
according
question?
to the Robert's Rules
Robert's
of Order,
Rules of Orders.
you have to be recognized by the presiding officer.
And
That had,
Ms.
that,
Gregory, let me finish my question. I find it hard that we sit here and everything I've heard, I truly believe that they were acting in the best interest of the housing authority. I don't think that they committed any misconduct or acted inappropriately, because trust me, I would have took the same stance.
But I would like to say this, Mr. Chairman, even though it was not in the
I
motion.
need to recognize you. I need to recognize you. So, enough said.
Even though it was not in the motion, but Mr. Fambro also changed the locks and the computer without permission of the board.
Absolutely, but he also stated as to why he took that action.
We have a
And
motion on the
again,
floor.
I would take, no, and it's been second. Again, they didn't act inappropriately in my book. Any other questions?
I do have a statement. So commissioners can be removed when we don't follow legal counsel. Is that the standard?
Are you asking that?
I mean,
of
it's
this board?
rhetorical, but
Because, yes, because that seems to be the direction that we are going in.
Mr. Chair, and you know, and while we're in this discussion, let me just remind everyone, this is not anything different. A couple of years ago, we had two members removed from the one member from the Tax Assessor Board, one from the Water Authority Board. You know, there was, you found calls that I disagree with to remove those members. So, you know, for us to come in here and, you know, let's just go on with the matter of business.
well, I do want to address that. They weren't removed. There was a lawsuit filed by the district attorney for a breach of Open Meeting Act. As a result, they were not appointed. They were not removed.
They were removed.
Okay.
They were removed.
Motion.
All right, let's
They
move
were
on.
removed.
Are there any other statements or comments? Hearing none, those in favor, aye.
Aye.
Opposed?
Nay.
3-2. Is there another motion?
Yes, sir, Mr. Chair. I make a motion that Mr. Michael Bryant be removed from the Housing Authority Board again for misconduct and going against the advice of their legal authority in the execution or however they did the indefinite suspension of the Housing Authority Director and so forth.
I second.
Probably moved and second. Any questions or statements? And again, I personally do not find any misconduct or inappropriateness in his actions. Those in favor, aye.
Aye.
Opposed?
Nay.
It's 3-2. It passes. All right, being no other business before this board,
For this
Yes.
hearing.
for this hearing, I'm sorry. Motion to adjourn.
So moved.
Is there a second?
Second.
Probably moved in second. Those in favor, aye.
Aye.
Opposed? It's unanimous.